I'll request my colleague, Ms. Sakhi Shah, to just give us some of the house announcements, and then we'll hand over the mic to my senior colleague, Mr. Bipul Chatterjee, for his introductory remarks. So Sakhi, over to you.
Hello, everybody. Am I audible? Am I clearly audible to everyone?
Yes, you are.
Okay, perfect. A very, very warm hello to everyone present today. I am Sakhi Shah, and I take great pleasure in welcoming you all to this webinar on competition enforcement for business collaborations during COVID-19. It is an absolute honor to have you all join us to participate in this very timely and pertinent discussion with some of the most remarkable minds in the field of law. Before we begin, I would like to take you through some certain house rules. Firstly, all panelists and participants are requested to be on mute for the duration of the event. The host Udai and the co-host Akshay will unmute speakers as and when necessary. Secondly, post the panel discussion, the floor will be open for questions from all participants. In that case, the participants can post their questions directly to the host through the chat option present on their windows. And then depending on the time availability and other factors, your questions will be posed and during the discussions. And lastly, if any panelist or participant wants to intervene during the length of the webinar, please raise your hand. Again, the option should be available on your Zoom screens, or you can also alternatively write in the subsequent chat boxes. I would also very quickly like to mention that we have had over 200 registrants who will be viewing this webinar through the Zoom link or from YouTube. These registrants are from cross-cutting geographies, including Asia, Africa, Europe, North and South America. So once again, I welcome you all. Thank you for joining us. And now, without taking any more of your time, I would request Bipul Chatterjee to please present the opening remarks. Thank you.
Thank you, Shakib. To begin with, let me join my colleagues in warmly welcoming all of you on this very important subject of today's discussion. Before that, let me say good evening or good afternoon or good morning to all of you, depending on the location where you are. Now, today's webinar, the title says it all. I mean, let me, in my welcome remarks, try to disaggregate it. First is during COVID. So we really don't know what would be that period during COVID. Now, broadly, we are seeing that there are two types of measures which are being taken by various governments. One is to address the health-related issues, and the other is to address economic woes for economic recovery. Now, all of us, I guess, would agree that we are going through this unprecedented time, and therefore it's not surprising that unprecedented measures are also being witnessed. Whether they are hindering competition, that's a question which we are going to address today in our webinar. Ultimately, we need to see whether, as a result of these measures, who are getting the benefits, or who got the benefits. Is it consumers, or is just the business which are benefited as a result of such measures? So I'm not going to go into the details because we have prepared a discussion paper, and my colleague Sakhi, she is going to make a presentation. All I would say, and this is my personal opinion, that I think even after all these measures, economic recovery is going to be very, very difficult. So we really do not know what kind of measures that we need to take. I'm talking about fiscal measures, monetary measures, even other measures. Even taking all these measures into account, I think we are going to see a much, much more difficult situation in near future and for quite some time. So with these few words, let me once again welcome all of you and request Sakhi for her presentation. Thank you.
Hello, everybody. Once again, welcome. I will be taking 10 minutes of your time to present a discussion paper which is authored by Udai and I on the same topic. Just give me a moment to just share my presentation. Is it visible? Can everybody see the presentation?
Yes, we can see that.
All right, okay. Okay, so basically, this webinar is a product of the paper that Udai and I wrote. After we finished writing the paper, we realized that we should not be restricting our research to simply writing a paper, which is why we wanted to go ahead and discuss it with, as I said earlier, some of the remarkable minds in this field. Having said that, without taking much of your time, I would like to give you a brief outline of my presentation. I have divided my presentation in three main parts. Firstly, why are we, amongst many others, talking about this right now? That is, why is this important? Secondly, the findings from the survey conducted by us at CUTS International, which gives an overview of how competition agencies worldwide have responded to this pandemic. And lastly, recommendations which can be adopted by competition agencies to address the COVID-19 crisis. Coming to the first part of my presentation, the why. One of the biggest consequences of the COVID-19 pandemic has been the deep economic depression. This led to an instant shortages of essential goods and services and a further collapse in demand. This was mainly because of the lockdown measures taken by governments all over, which made it almost impossible for consumers to access brick and mortar stores. Owing to these demand and supply shocks, businesses have felt the need to collaborate with each other to ensure supply of essential goods and services. To ensure the latter, competition agencies have adjusted their enforcement priorities. They have granted exemptions to certain collaborations, and they have allowed state aid. For instance, the Australian Competition and Consumer Commission has granted individual exemptions to more than 10 sectors to work in collaboration. At the same time, competition agencies have also made it very clear that businesses found taking advantage of the pandemic to go beyond what is necessary will not be tolerated. This is evident from multiple enforcement actions which have been initiated by different competition agencies during COVID-19, such as in Kenya, South Africa, USA, Brazil, Poland, Turkey, to name a few. This clearly shows that authorities have been vigilant and are closely watching markets and the behavior of businesses. This is important as previous research has shown us that a relaxation in competition laws during economic depression or recession is likely to further the same. And in that context, it is important now than ever to further competition in the market during and post COVID-19, as we can easily relate and link competition to productivity growth. This brings me to the second part of my presentation. The survey that we conducted targeted competition agencies worldwide. We received 15 responses from varied geographies, including Europe, Asia, Africa, Australia, and North America. Even though the number of respondents is not substantial, it is nevertheless important to discuss the findings as they help give an overview of how competition agencies have responded to the current pandemic. One of the first questions that was posed to the agencies was to understand how they determined which sectors or goods and services should be exempted from competition enforcement during COVID-19. Without much surprise, majority of them stated public interest would be the most relevant determinant. In this context, however, a case needs to be made to balance consumer welfare and public interest. In a lot of cases, it has been noted that promoting public interest may paradoxically lead to lower consumer welfare as market competition is weakened. In that case, should competition agencies use necessity and proportionality or increased efficiencies as primary determinants to grant exemptions? This brings me to the next question that we posed to the competition agencies, which was that which sectors did they grant exemptions to? It was found that majority of them granted exemptions to retailers, with most of them granting exemptions to wholesalers and distributors of pharmaceuticals. However, one of the major concerns which was highlighted through this question was that no agency had granted exemptions for research and development. This is highly problematic as it is crucial right now to allow collaborations in research and development even beyond national boundaries so that we can combat and cure this particular pandemic. The fact that no exemptions have been granted in this sector could be a result of either first, wrongly identified determinants, that is, as I mentioned earlier, if increased efficiencies or necessity and proportionality would have been given more weightage, it is possible that research and development would have been a sector which would have been exempted. And secondly, it could also be because of increase in protectionist measures nationally that countries have not relied on research and development amongst each other. This led us to our third important question. That is how competition agencies are ensuring that businesses do not take advantage of the exemptions which have been granted. The most opted measure by competition authorities has been firstly to assist businesses and secondly to encourage consumers to notify any anti-competitive behavior of businesses. It becomes clear that the rationale behind assisting and guiding businesses is to curb any collaboration or activity which is unnecessary in these times. This would also ensure that collaborations do not last longer than necessary, thereby reviving competition in the market in the medium to long term. This is especially important and relevant in the Indian context, as the Competition Commission of India has not provided any significant advice or assistance to businesses. And at times like these, what is required is for agencies to provide specificity either in relation to the decision timeline or the types of conduct that would likely to be cleared or will be problematic. The next question that was posed to the agencies was which actions by businesses will invite immediate competition enforcement. This question provides certain clarity which is important to help us curb anti-competitive conduct and also minimize and mitigate unnecessary litigation claims. It was found that majority authorities would not tolerate price fixing by businesses and that most of them will not tolerate any collaborations which are non-essential and last longer than necessary. However, the interesting find is that many agencies have placed price gouging, which is essentially a consumer protection issue, at par with typical competition contraventions such as tie-in arrangements and exclusionary conduct. This has also been observed in various investigations that have been initiated by competition agencies worldwide against businesses for indulging in price gouging. This reflects that competition authorities identify that consumer protection issues have the potential to harm competition in the market. And one of the last questions that we posed to the agencies was whether they would be willing to prolong the current exemptions post-COVID-19. What is interesting to note is that all 5 agencies who responded yes are all from developing countries. Their reasons mainly ranged from relaunching economic activity to furthering public interest and technological efficiency post-COVID-19. This is an important question which needs to be addressed, as it has been noted that competition law can act as a barrier to achieving certain goals through cooperation between businesses such as climate change and sustainability. Is it then appropriate to say that competition might be context specific, that especially for certain sectors, war of all against all is not a good model? This brings me to the last bit of my presentation. We proposed the following 6 recommendations in our discussion paper with specific focus on the Indian context. However, they can be applicable and are relevant to any country with a similar socio-economic background. The first recommendation is for competition agencies to clarify the forms of collaborations that would be unproblematic, for businesses to carry on functioning without being fearful of competition enforcement. This clarification becomes very important. Secondly, at times like these, it is also important to emphasize the importance of trade associations, as major industry concerns will have to be addressed. And however, this must happen whilst ensuring that such associations do not become platforms for coordination or exchange of sensitive information. The third recommendation is that competition agencies should identify essential versus non-essential commodities. We understand that in a crisis, the essentiality of any commodity is a fast evolving concept. However, an attempt needs to be made to bring greater clarity to businesses. Fourthly, competition agencies should provide guidance to businesses. As I have mentioned earlier, this can help curb any unwanted and anti-competitive activity in the market. Another recommendation is that agencies should provide for a notification system for business collaborations. This will not only help clarify the legality of such business collaborations, but it will also reduce frivolous and unsubstantiated lawsuits. And lastly, competition agencies should aim at increasing transparency. This is the best way to comfort consumers that the best possible competition-friendly approach has been taken, which furthers consumer welfare. We are faced with incredibly unique and challenging times. There has been a collective experience reminding us all how valuable cooperation and collaboration is. We hope our paper and this webinar helps understand if that experience can be allowed between businesses. This brings me to the end of my presentation. Before I hand over the floor to the panelists, I would like to take a moment to thank all the competition agencies who responded to our questionnaire and all the reviewers who provided us with timely and detailed comments on our paper. I now hand over the floor to Pradeep Mehta, Secretary General CUTS International, to commence the panel discussion. Thank you, everybody.
Thank you, Sakhi. Can you switch off your presentation?
Yes.
Thank you very much. And that was an excellent presentation by you of the study that we did.
Thank you.
And I'm sure if we continue to make the same efforts to bring out a second version by contacting more people, as I see, in terms of participation, as I see from the attendance, there are people from all over the world who have joined in. As far as Japan in our east and Peru on our west, so it's quite a wide spectrum of the audience, and we hope that they can take the message forward to see how we can define it. An important question was raised by Bipul in his opening remarks. And we have to look at the situation during the pandemic and post-pandemic as well. We don't know when the post-pandemic period will arrive. It's still so uncertain. A friend of mine was writing in the newspapers yesterday in India. And in terms of trying to revive the lack of growth, I mean, there is contraction happening in many economies, including probably UK is one of the worst examples. There is less contraction happening in India, about 5 to 6%. He even suggested that we should look at cartels benignly and set floor prices as one of the possible ways forward, other than, of course, suggesting that the government must borrow uh, in order to lubricate the economy, and in spite of it, not being worried about the fiscal deficit. I mean, a high level of fiscal deficit could lead to high inflation, which means again consumers would be at the short end of the stick. But that is, I'm sure these issues will come up in our discussion, both in terms of how does it relate to a competition regime and how does it relate to economic governance as a whole. Both these issues are intertwined and one cannot separate one from the other. Therefore, may I now request Fred to please kick off the discussions. And I have a few questions to each of the panelists, which I would like to raise. One of the key questions this pandemic has raised is the importance given to consumer welfare under competition assessments. Do you think there is a need to revise the traditional principles of competition law to consider it to be other factors such as greater public good or sustainability? And secondly, and what should be the competition enforcement approach with respect to post-COVID-19 economic recovery and / resilience? Over to you, Fred. And I would expect that speakers should take about between 7 to 10 minutes max, so that we could try and have a better floor interaction. Over to you, Fred.
Thank you very much, Pradeep. I'm not directly going to address the questions that you raised, but I will, in the end, mention them. I want to go back to the present situation, first of all, because it seems to me that post-COVID is going to be in the distant future, not very soon. And I want to analyze more precisely what we've been through to try to explain how competition authorities reacted. And this is indirectly an answer to your first question. So what we have seen is a breakdown in the price mechanism, as Sakhi mentioned earlier, due to the fact, combination of things, huge spikes in demand for some products, and particularly everything that's related to health, supply breakdown in the value chain because of the national measures which have been taken. And as a result, an impossibility for supply and demand to meet at any price, unlike what we have on traditional markets. Okay, so that's the first thing that we had to deal with. The second thing is that this disadjustment had a particular dimension, which I want to emphasize, which is the fact that it produced a negative externality on society. Because as long as we could not have a sufficient supply of masks, medicines, testing equipment, etc., it meant that the pandemic was developing. So the lack of adjustment led to a very important negative externality, which raised two questions. One of them is the question which is very rarely asked in competition law of the time it takes for a market to adjust. And clearly there was no time to wait because of the negative externality. And the second thing, which I will come back to later on, is on efficiency, the fact that some cooperation between firms were, because of this negative externality, more likely to lead to economic efficiencies than the traditional analysis would suggest. The third dimension was that to try to limit the extension of the pandemic, the basic answer in many countries has been some kind of lockdown. Now, lockdown means that on the demand side, demanders are less flexible, they cannot travel, they cannot compare as easily prices, And this has led to a huge constraint due to the lack of mobility on the demand side of people. And the fourth dimension is the uncertainty. As long as we don't have medicine, as long as we don't have vaccines, we don't know how long all this is going to last, and therefore that increases the level of uncertainty, which does mean the fact that some decisions, particularly when it comes to mergers, can be even more difficult to make than they would have been otherwise. Okay, so all those four elements have to be kept in mind. And as Sakhi said, there have been two types of reaction, one on price gouging, one on cooperation. Now, for the sake of time, I will only talk about cooperation at this point. The cooperation that we talk about in the context of COVID-19 is different from the cooperation between firms on two grounds. The first one is that it's mostly a cooperation to try to either increase supply as opposed to restrict supply, which is a typical cartel situation, or to improve the allocation, make it more fair or more efficient, the allocation of whatever supply there is. Make sure that the hospital workers get the masks that they need, not to be infected themselves, that kind of thing. That's the first one. The second one is that as long as we do not have a supply that meets demand at some reasonable level, the externality, which I talked about earlier, weighs on society, and there are more and more people who are likely to get the disease. Now, what does that mean? It means that when we look at efficiencies, one of the conditions, which is usually never met, is the fact that those efficiency benefits should accrue to the consumers for a fair share. Well, in the case of cooperation within the COVID crisis context, the sheer fact that firms can try to get together to get a better supply of masks, a better supply of vaccine, a better supply of medicine, a better supply of respirators, you name it, in itself is likely to reduce the spread of the disease, which in itself is an efficiency. And that's why you have, for example, the CMA was very clear on this, to say that when it interprets the conditions for efficiency, it would consider that cooperation between firms to try to increase the output in order to be able to meet demand would nearly automatically fulfill the condition that there was a fair share for consumers. Okay, so let me just say one word about the reaction of different competition authorities when it comes to this, to cooperation between firms. I think that we've seen very different talks on the part of competition authorities, depending on a number of things. First of all, the freedom with which they can prioritize their cases. And we know that there are cases where you cannot do that because you have to take up all the complaints, and other cases where you can decide that you're going to prioritize. And clearly competition authorities that were able to prioritize have used this to pursue a policy goal, so to speak, by not going after some of the collaboration. The second dimension is the extent to which there are public interest goals in the competition law. Now, we know that in most developing countries, but also in a number of developed countries, there are public interest goals that are written into the goals of the competition law. And of course, that explains, and we know from previous work, particularly at OECD, that this is much more sensitive in developing countries than it is in developed countries. So the more public interest could come into the play of competition law, the easier it has been for competition authority to accept cooperation. The third one is the dimension that was talking about flexibility and efficiencies. Yes, I'm finished in 3 minutes. Flexibility, 3 minutes. Flexibility in efficiencies, the criteria under which efficiency can be accepted, and how the circumstances made it easier to accept those efficiencies. And finally, the fourth dimension is the extent to which the competition law could accommodate, could be flexible, or had a very strict interpretation when it comes to cooperation between firms. Okay, so if I go across the world very rapidly, we have the countries that pretend that there was no problem. So this is the ECN statement that said, oh no, cooperation to increase output is never anti-competitive and it's always efficient, okay? Then we have a second position, which is the position of the EC, which says, well, to get there, there must be exchange of information, which could be anti-competitive, but given the circumstances, given the fact that there are efficiency benefits, which are much easier to realize, I will not prioritize. I will use my ability not to prioritize these agreements. The third one, I would say, would be the CMA kind of approach, which is a combination of public interest. I want to protect the weakest consumers, and B, I want not to relax my efficiency criteria, but I want to adapt them to the particular circumstances which I've mentioned earlier. And finally, we have countries, finally, last sentence, we have countries where there was still a resistance to the idea that competition law should deal with those issues. And this would be South Africa, this would be, to a certain extent, Australia, which has been mentioned. And there, the answer was to exempt either this category of agreements or sometimes a whole sector from competition law, okay? So there have been different laws, but in all cases, there's been a movement towards being more understanding. And I think the reason for that is the clear understanding that not acting fast, not pushing collaboration to try to get an increase in supply entailed a massive negative externality in society. Finished.
Thank you very much, Fred. And we are now move on to Eleanor. Eleanor, I have a few questions for you. We are witnessing the revival of industrial policy and a greater protectionist measures during and as a consequence of the COVID-19 pandemic.
Yes. So thank you. Hello, everybody.
Well, can I complete my question? Yeah. What challenges could that pose for competition authorities, if at all, if it comes in their jurisdiction? How can we balance between industrial policy and competition law? And secondly is, can competition help achieve other policy objectives such as sustainability, climate change, gender equality, and simply a narrow efficiency objective, as was mentioned by Fred also, that in the developing world, public interest considerations are considered to be of a higher priority than just efficiency. Over to you, Eleanor. 7 to 10 minutes?
Yes, okay. Thank you very much. I will back into your questions. They're great questions. I want to commend you and Cuts for the wonderful discussion paper and this program too, which is very important. By backing into it, I have 3 big points, and then I'll come out more directly in answering your questions. So this, of course, is all against the background you all discussed, and Frederic most recently in talking about how agencies are thinking of ways to relax or bend or even exempt, and sometimes even giving exemptions to whole sectors. My 3 points are, there is a bigger picture of which this is a part that I want us to concentrate on for a moment. Second point is, in view of the scarcity, what to be done, and of course that's the main point of this conference. And third point is, focusing on the most vulnerable and thinking about developing countries and looking at the problem through the eyes of developing countries, which you, Pradeep and Kutz, have been so instrumental in doing. And since they are the most vulnerable suffering the most slings and arrows in this pandemic, I think it's very important for developed countries too to sit back and say, what do the most vulnerable need? Okay, so for big picture, going back to another big subject that everyone has been talking about, we are in a world of increasing concentration of business, of increasing nationalism and very parochial nationalism, which also means less pressure on competition from abroad, less good international competition, great vulnerability of consumers, and concentrated to worry about the most, including airlines, healthcare, supermarkets, big pharma, energy, banks. And a very interesting aspect is the same industries that we're worried about increasing concentration, that are hurting consumers and hurting competition in the market, are the same industries that we're focusing on in terms of, do they need special treatment now to produce faster, better, deliver better for the people? So this has to be brought together. And how I bring it together is this: skepticism. When big companies, leading producers and big industries say, oh, I need to collaborate for the good of the public interest, think about that background. Because the more we allow the collaborations, the more we have the increasing concentration where it hurts the most, the more there is a public spirit of at least competition, market-minded people in the world to say, this is too much, we have to do something about it. All right, number two, coming directly to the scarcity problem in the pandemic, but of course this is very related. My thought is, we have to be skeptical of the claims for the need for collaboration. I think many agencies are, but as your discussion paper points out, unlike in the financial crisis of 2008, where agencies were really skeptical about the needs. They know there is the need. I'm not questioning the need, but they were skeptical and they wanted to see where competition would work. I see a bandwagon of agencies saying, oh, we have to be very careful to give a broad swath of freedom to companies, especially in those areas we're worried about increasing concentration, because we need to meet the needs of delivering, producing and delivering scarce product. So that point would point in the direction of, don't give exemptions or privileges to large swaths of industry, but require very particular showings of where is the need? Is this collaboration necessary for it? Is this big a collaboration necessary for it? How much and how well can we monitor the termination of the collaboration and prevent the continued effects from the collaboration? Also, in terms of meeting the needs of the pandemic, process, as you've already pointed out, and institutions are extremely important. Access of consumers to complain, a quicker review and more business review letters to determine whether the collaboration is permitted. Also in this point of how to deal with the scarcity, and maybe even adding another recommendation to your recommendations for India, I would say there's a bigger need for agencies to be clear about what is and is not anti-competitive and what modes and models and formulations to use to determine what is or is not anti-competitive. A huge amount of what is efficient, most of it, is not anti-competitive and would not be prohibited under normal rules. And I think there is a danger of agencies coming to the conclusion that, oh, this must be anti-competitive and therefore it must need an exemption or a relaxation, when maybe if the analysis of what is anti-competitive is clearer, you realize it doesn't need the exemption. For example, collaboration on research and development to get a virus. Research and development collaborations done right, and not including the whole world, are usually very pro-competitive. So that doesn't usually need relaxation. Let me, this issue was raised by all of you and definitely by Frederic just now. I think it's very important to have truth in analysis, and some jurisdictions are bending the law without saying they're bending it, and other jurisdictions are being more straightforward as to whether certain collaborations that are indeed needed to deal with the scarcity problem, they are needed and they may be anti-competitive. I think it's important for the agencies to call it as they see it. Yes, this is taking a lot of competition off the market, and normally we would think it's price raising and output limiting, and the companies have, for example, mapped out just how they're going to produce more, deliver better, and it is either, then you have the hard question. Some jurisdictions' law does not, competition law does not allow the flexibility to approve, and the agency can say, I won't enforce. The companies can be too concerned to go ahead with a very important venture. I think that would be unfortunate. I think it seldom would happen. I think, as Frederic pointed out, where countries have public interest in their law, they can be forthright, they can do the right competition analysis, they can, where it's warranted, come to a conclusion, yes, it's anti-competitive, it's normally prohibited, except that we have public interest and it's really important for the public interest. Just the last point, just to say a word about developing countries and the most vulnerable. As Rawls said, the test of a society is how it treats its worst off. We know that the pandemic is devastating developing countries, much worse than developed countries, even though it's devastating a lot of developed countries. I think it's extremely important to listen to, I mean, this, of course, me coming from a developed country, I'm listening to you, but I'm saying very important to listen to the voices of the developing countries as to what they need to prevent the disaster from happening as bad as it's happening to those who are the most vulnerable. So I'm listening, and thank you.
Thank you very much, Eleanor, for maintaining your time also and raising some very important issues. You did answer the point about the issue about protectionism, increasing protectionism. I'm talking about trading across borders particularly. Overall, there is I'll come back to you on this later in the question and answer section, but I just thought to sort of give you a heads up on it. May I now request Bill Kovacic? The two questions that I have for you is, how can we further collaborate between developing and developed countries to ensure harmonious application of competition laws at such unprecedented times? Do you think the current competition law mandate is adequate? More specifically, are the remedial tools sufficient to address concerns arising out of the new normal? Over to you, Bill. 7 to 10 minutes.
Thank you, Pradeep, and my congratulations to the team for producing a very useful paper and doing the survey that is the mark of a really good think tank. So, and thanks further for the opportunity to participate. Let's start by talking about cooperation. It almost becomes a cliche over time to talk about the desirability of greater cooperation. I would like $1 for every program I've gone to where people say, almost as a essential part of a presentation, we should cooperate more. How to do that? What's a useful focal point? I think the cooperation that is most useful between a more experienced agency and a less experienced agency is the exchange of know-how. It's not about technical concepts, it's about how you do things. Don't tell me about the broad overarching analytical framework. Tell me how you apply it in practice. And I think there's a lot of know-how that's been generated during the course of this experience over the past 8 months or so that is useful to convey. What is that know-how? I use the experience I've had at the CMA. I'm not speaking on their behalf, but I'm talking about some things I've done that have been very useful in responding to these circumstances. For starters, agencies are in a really tough position in that they have to make decisions quickly in the face of events that change by the minute and in a sense are overwhelming. And in the background, if you're a competition authority and you are seen to be too slow or too inflexible, what is the hazard to you? You'll be accused of killing people, just like that. You killed them because you didn't respond, because you dragged your feet talking about broad ideas about how competition is good. So if you're not going to move quickly and you're not going to be seen as responsive, you will be accused of contributing to a calamitous healthcare failure. That's in the back of your mind. So how do you respond to this? One bit of know-how, one valuable thing that the CMA did some time ago was to increase its capacity to analyze data. They created a data specialist. They have an office, a small but very effective unit of people who are data technologists. It put them in a position very quickly to analyze trends. That is, where were the complaints coming from? They told the larger society, give us your complaints right away. They had the capacity in real time to analyze patterns in those complaints. So almost on a daily basis, they had a sense of where the social problems with respect to competition or consumer protection were developing. A second thing they did was to publicize those trends. One thing I think an agency has to do to be seen as effective is to be seen as visible. So for policymakers and the larger public, they started putting out reports each week saying, here are the trends, here are the problems, here are the hotspots, and here's what we are doing to deal with them. The fact of having a visible, immediate presence provided some assurance that the authority was being responsive and was being responsive in an effective way in dealing with problems. A third thing they did, and this certainly goes back to the report and one of its main recommendations, is that they provided a lot of guidance quickly. Now, was this perfect guidance, elegant, lots of footnotes, fine details and nuances? Of course not. In many ways, for policy agencies, this is the equivalent of being on the bridge and hearing from the lifeguard, the people in the crow's nest, iceberg dead ahead. So what do you do on the bridge? Let's see, iceberg dead ahead. Well, how big is the iceberg? How fast should we turn? Should we turn left, turn right? Do we have the right kind of boat? You have 10 seconds to make a decision that will save your ship or will kill the vessel and lots of the people on it. So part of the guidance, in a sense, is experimental. It takes a rough form, but I think what the agency did was to realize we have to provide the best information we can quickly to give people an idea what to do. We'll fill in the details later. A fourth bit of know-how is that the CMA benefited from the integration of having a competition and consumer mandate. That's part of your question, Pradeep. Having both of these under the same roof and being able to draw upon them. So in thinking of cooperation, you need a platform or a forum where people can speak. But the kind of discussion that is useful, I think, is a detailed reconstruction that allows you to convey know-how. This is, here's the problem, here's how we responded, these are the things we did. And some of the lessons, I think, from this experience to date is you have to have a way as an agency of assembling and analyzing data quickly to see where the problems are. Not to identify a trend, 5, 6, 7 weeks after the problem has emerged, but to identify it almost in real time, in days, not in weeks. Second, to have a process by which you tell the public a lot about what you're learning and seeing. So they have confidence that you're looking, they have confidence that public administration is responding, that you're giving guidance, and yes, you're drawing on the capacity inherent in the mandate you have. In the case of the CMA, it's a competition and consumer protection mandate. So what I would like to see by way of cooperation is not a generalized discussion of big concepts. I'd like to see detailed case studies in different fora in which the authority says, this is what we learned, this is what we had to do, this is how we did it. Final thought, what about the mandate? A good thing about a crisis is not its calamitous effect on public health, but it's the opportunity to experiment. When you have a crisis, you have a lot more freedom to try new things out and to try things out that in a sense are unconventional. So this is an opportunity for agencies to test the full potential inherent in the mandate without the concern that someone's going to jump on me and say, oh, you stretched too much, or you tried to stretch. This is an opportunity to be creative. So one of my thoughts for agencies is I would be creative. And if someone said, oh, wait, you've driven outside the lines, I'd say, in case you haven't noticed, we have thousands of people dying by the week. Would you like me to be very cautious here? Or would you like me to try something new? So this is an opportunity to do creative things with the mandate. I'd test that mandate aggressively in this setting. And then I would say, once we have some return to a more placid environment, I would ask myself, what was missing? What was not in the toolkit that I would have used? When I reached for the toolkit, what wasn't there? So that I had to use a hammer instead of a screwdriver. What was there? What wasn't there that I want to add to the mix? And to do that careful inventory of what I had and what I needed, and to use that in short order to go to my legislature and say, this was a stress test. It put an unmerciful light on what I had and didn't have. These are the weaknesses it's exposed. This is what I want you to do about it so I can respond to this more effectively in the future. Thanks.
Thank you very much, Bill. May I now invite Shaista Bano from the Competition Commission of Pakistan, as you know, the points which were raised by Bill can segue into what the response that we are seeking from you. Two questions to you, Shaista. How does the Pakistan Competition Commission approach consumer protection issues which can beat anti-competitive outcomes, especially during this pandemic, considering that the Competition Commission of Pakistan has a singular mandate? Secondly, what is the need of the hour for developing countries regarding competition enforcement? How can we ensure more transparent and optimal regulation of competition in markets during and post-COVID-19? And before you start, I have a relevant question which I thought I could pose to you. Is, you know, in many countries, price capping, medical devices, PPE kits, etc., etc. And how far do you think this regulation should go? Over to you.
Thank you so much, and I really appreciate this initiative by CARDS. And I also thank you for letting us participate and give our perspective on various issues. Firstly, as per the question, I would first briefly touch upon some provisions of our law that particularly deal with consumer protection. Consumer protection is basically addressed in the preamble of Competition Act, which states that it's an act to provide for free competition in all spheres of commercial and economic activity to enhance economic efficiency and to protect consumers from anti-competitive behavior. So the various pillars of our law directly or indirectly deal with consumer protection, and it is the core of in the core of the Competition Commission and our enforcement activities. While we deal with abuse of dominant position under the law and the prohibited agreements, Ours is a compulsory merger regime where every merger has to be notified, which is meeting the thresholds that are provided in the law. And our section 10 of the Act particularly deals with deceptive marketing practices, which include distribution of false and misleading information and fraudulent use of trademark. Our law do provide with exemptions from prohibited agreements, and these exemptions could be individual exemptions. They deal with the individual companies or undertakings, and there are also block exemptions provided in the law. And in order to qualify for an exemption, the entities have to show that any anti-competitive effect are offset by the economic or technical efficiencies, the benefit of which is passed on to the consumer. So there is a test of passing the benefit to the consumer that is provided in the exemptions test as well. So talking about the pandemic, it was also a real challenge for the Competition Commission of Pakistan as well, like the other countries. Our GDP growth was shrinking by 0.4%. There was shrinking industry and services sectors. So it impacted almost every sector of our economy. And the second part of the question was how we dealt with the consumer protection issues and anti-competitive behavior during this pandemic. So we can divide it into two sections. There was surge in the prices of all the essential commodities, mainly due to the disruption in the supply chain. So various cases were also referred to the Competition Commission of Pakistan. So I'm just having some throat problems, so just need some water. So we will forward various cases of surge in prices of essential commodities due to supply disruptions. There was a drop in the demand of various products, and especially those products which are imported and which are transported from one province to the other province. We also received some complaints on the increase in the prices of some health-related products, like face masks and like sanitizers. So they were in the shortage. So while we were all facing lockdown situation, so these things were natural. We actually so after the conditions of the pandemic were the cases were dropped a little bit, the government relaxed the lockdown situation and converted it to smart lockdown. The transportation conditions were improved, so the prices began to go back to the normal. However, like in the other developing countries, ours is not a social security regime. So the government has to introduce some stimulus packages for revival of industries and for the welfare of consumers. So these, in order to incentivize certain industries, government is giving various kind of incentives. So as a competition agency, we are trying to see whether the distribution of these incentives is going to affect the level playing field or not. So in certain cases, as you rightly mentioned, that there is a price capping in essential food commodity sectors to ensure food security. So that is also, especially in the wheat, flour sector and the sugar sector, there are price cappings. And they have been introduced by the government, but they were already present in Pakistan. it was nothing, there were no new price cappings introduced after the pandemic or as a result of pandemic. Competition Commission of Pakistan is looking into these price caps which have been introduced, and we have a mandate to issue some policy notes and opinions, and through these policy notes and opinions we are trying to address these issues, how they affect competition. So in our opinion, the price fixing is an antithesis of competition. So, but however, the priority of the government is to ensure food security at reasonable prices. And there are always chances that during the pandemic situation, certain players can manipulate the situation to get undue profits, and they tend to cartelize. We have to check we have to monitor them closely in order to check any such practices under our law. So the government has also introduced a special package, for example, for in order to create jobs in the construction sector. They are offering huge incentives to the construction industry. So after these incentives, there is a likelihood that there would be increase in the demand of these construction related products. So the government, after the increase in demand, we hope we could realize that there could be possibilities of cartelization in the cement industry, in the steel industry, and various other allied industries. So we are closely monitoring these industries to check any possibility of cartelization in these sectors. So we have also modified our enforcement priorities. And for enforcement priorities, our main priority is the essential food sector, which is in order to ensure food security and for equal distribution of incentives among the various consumers. So we are also going to check whether these incentives are manipulated by the large market players for their own benefit. So
thank you very much. Thank you very much. May I now move on to Teresa? The two questions that I have for you is, there is no debate in the current times is complete without talking about how the big tech are already coming out of this crisis stronger than ever. You know, this is a kind of a parallax which we need to address. This disrupts the MSME business models and increases concentration in the market. This clearly is going to have an impact on the agenda and priorities of competition agencies. What changes should we foresee then? Particularly if you notice, I mean, what we have discussed is came out in our Sakhi Shah's presentation is that consumers are not able to go to brick and mortar stores, but they are going through e-commerce, and the large platforms are naturally expanding their businesses quite well. Second question is that various intergovernmental agencies, including UNCTAD, have stated that competition authorities should grant exemptions to certain essential business collaboration during COVID-19. However, not all competition agencies have the adequate human, technical, and financial resources. In that case, how do you ensure that this advice can be useful or not? Over to you, Vlad. 7 to 10 minutes, please.
Okay, well, thank you very much, Pradeep. And again, thank you for the invitation and congratulations to CUTS for organizing so many, so diverse, but so active discussions and also papers on key issues regarding the situation that we are going through. Let me just say a couple of words before I actually start asking, replying or offering some replies to your questions. First of all, obviously the extension and the expansion of the pandemic has led to increased roles of government and of public policies. And this in a way is relevant for the discussion of business collaboration, because in several jurisdictions, governments have been adopting sector-specific or team-specific legislation that has an impact in business cooperation. And in a way, it is important that competition authorities are heard, are consulted, are involved, and provide the best of their expertise in order to make sure that these collaborations are exceptional, are temporary, are subject to conditions, are subject to monitoring. Otherwise, this will probably lead to a restriction of competition in the long run. Second, as other speakers mentioned, I think the fact that the multilateral trading system has been undergoing several changes, as we all know, for a number of years, but especially due to the pandemic, a number of protectionist measures starting to appear all over the world, also paves the way for the need for renewed and more assertive competition policy. So I think it is extremely important that competition authorities all over the world are fully aware of this opportunity in a way, also to do more advocacy, to reach out to other public bodies, relevant stakeholders, in order to make the best possible case for the benefits of competition, not only in the current situation where a lot of adjustments are needed, namely regarding business collaboration, as we have heard, but also in the long run, because of course we have several very serious challenges lying ahead. Now, UNCTAD, as you mentioned, and I go to your second question first, if I may. UNCTAD, when we issued a news release in the beginning of April, well, we recommended, between brackets, that competition authorities be flexible enough to grant, if necessary, exemptions for horizontal cooperation agreements in order to maintain the supply of key essential consumer goods, or in some cases for research and development purposes. Of course, not every jurisdiction, unfortunately, may have a level of research and development that actually justifies agreements between competitors. But I think even the adaptation, for instance, of ventilators or existing medical equipment change into some sort of ventilators to help patients that were suffering from COVID-19 was already a very good example of the need for this collaboration. Now, having said this, it is true that I think what is essential is that we've always been aware of exemptions to competition rules for efficiency reasons, for pro-competitive objectives, as previous speakers have highlighted. Of course, these are exceptional, these are temporarily, these are usually, as I said, submitted to conditions and thereby monitored by competition authorities. And I think that even though the adjustment may be necessary in what regards the enforcement of competition laws across the world due to the situation, it is very important that competition authorities don't lose sight of this need to be extremely vigilant, of be extremely active. And if possible, and here I join what Bill has said, I do think there is an extremely good opportunity to provide guidance, either to use or adjust, if necessary, existing guidance, or to really provide guidance that can support businesses. But as Bill actually said, to enlighten, to clarify, to explain why is this necessary, or why are these business collaborations exceptionally authorized, so that the regular consumer understands that competition authorities are still vigilant. They are still implementing their mandate to the best of their capacities. It's just that they are paying attention to the context, and thereby remaining extremely important and necessary. I also would like to say that I don't think that this can be or this should be necessarily done just by competition authorities. And I go back to your question. I think that especially young and small competition authorities, or some authorities of developing countries that may lack some resources, should rely on other public bodies, for instance, ministries, on academics that do market studies, even reaching out, if necessary, to business associations in order to get information that allows them to monitor market development. This does not have to be a unique effort of competition authorities. I see a lot of merit in this collaboration, and I think, if I may also underline the role of consumer protection agencies, since UNCTAD has both mandates, as you know, I think it is extremely interesting to use the source of consumer complaints or the information provided and gathered by consumer associations and consumer representatives such as CATS, and put all of this together. So let's say gathering efforts and sources of information in order to have a clearer picture. I go to your second question. I do think that the increase of market concentration and the probable abuse of dominance conditions for digital players that we are already witnessing will require some sort of regulation. I don't think this needs to be something that works like a straitjacket for innovative business models, but I think it is important to make sure that due to the pandemic, innovative startups are not just bought up by big digital players, that there is still room for innovation while consumer interest is duly taken into account. I do believe that this kind of regulatory framework should always benefit from a strong involvement and contribution from competition authorities and from consumer protection agencies. And I think this is all for now. Thank you.
Thank you very much, Teresa. And with that, I would like to raise a question raised by one of the questions before I turn to Taimoon. Is we are talking about distressed sale or kind of hostile takeovers of stressed assets. This is something which all panelists may think about to respond to. Secondly, Teresa and Bill, if you remember, the US Congress had recently undergone a heavy scrutiny of all the big tech, and including coming at some kind of thing. I would like you to reflect on that later when we open up the floor. Taimoon, over to you. Taimoon, question to you is it reasonable to expect competition authorities to be well equipped to handle such situations such as COVID-19? Even government departments, including a health department, are finding it very difficult to manage it. In India, for example, I saw the health department coming out with nearly 500 regulations, one after the other. I mean, anything. So it was sort of all ad hoc approach, knee-jerk reaction, etc. So how do you expect competition authorities to be smart enough to be able to deal with this kind of thing? And what do you think are the special needs regarding competition enforcement in the post-COVID era in the small and developing? If you remember, we had spoken when we spoken last in a very closed event on Fred's paper that Caribbean economies, particularly dependent upon tourism, are very badly hit, and we're going to remain badly hit for some more time. Over to you, Taimoon.
Thank you, Pradeep, and thank you for inviting me to participate in this discussion. So, yes, of course, I am going to focus on Caribbean economies and CARICOM economies in particular, and to focus on the fact that in our smallness and the fact that most of us are island states proved to be a positive in this crisis situation, because we were able to close our borders, and unlike states that have borders with other countries, land countries, once we closed our borders and stopped commercial flights, that was it. Nobody could come in. And most of our countries still have borders closed. And as a result of that, there have been very few, relatively speaking, very few cases hospitalized and very few deaths in our region. So that's the good, positive side of it, that we have managed to contain the virus within our countries. The negative side to that, of course, is closure of borders mean that we have cut off the lifeblood to our economy. And whereas in large economies, There are many sectors. If one sector is cut off, like say tourism is the downfall or demise of tourism practically is affecting all countries. But it's the level of effect. And in our countries, in most of our countries, tourism brings in most of 80% of foreign exchange into our countries, foreign currency, and employs over 50-60% of the population, the tourism and tourism-related activities. And so by closing our borders, we actually cut off the lifeblood to the economy. So that is our dilemma here, that we safeguard health, and in the process, we have cut off our major economic activity. Why it is that earning foreign currency is so important for us? Because we import most of our consumables, and we need foreign currency to do that because our currency is not exchangeable. So if you cut off the earnings on foreign currency, it then reduces your ability to purchase your essential goods and services. So that is the problem of being small and being island economies dependent on tourism. And in the case of Trinidad and Tobago, dependent on oil. And of course, we all know what happened with oil. The drop in demand, the glut in oil, the collapse of oil prices, and Trinidad and Tobago's economy also is devastated because of that. They don't depend on tourism, but they depend on oil. So how have we dealt with the pandemic? Well, in terms of supplies, interestingly, we really have not seen any huge shortage of supplies, consumable supplies and medical supplies. So for medical supplies, the positive side of CARICOM is it has institutions and agencies that deal at a regional level with crises. We're used to crises. You look, every year you hear about hurricanes devastating economies, devastating countries. And again, one hurricane hitting 2 or 3 Caribbean countries, the tourism sector is again cut off for almost a year while they rebuild infrastructure. So we're used to crises, and we do have an agency in CARICOM for this disaster response. That agency is called, let me just see, the CARICOM, hold on. Yes, the CARICOM Disaster Emergency Management Agency that responds rapidly to crises. And usually it's natural disaster, but what they did this time was they immediately got together with the World Health Organization, got funding from the UAE and from another organization and the World Health Organization, and they had supplies, medical supplies, procured and sent into CARICOM and distributed through the countries. So the combination of not really needing too much of the protective gear for healthcare workers, etc., because we didn't have so many hospitalized cases, and the testing equipment, everything, the kits, etc., were brought in. So we didn't have any huge shortfall in supplies in that regard. In terms of goods, there's an interesting phenomenon I'm pondering on, and that is we haven't really had any great shortfall in goods either, except for the hand cleansing and supplies, the health cleansing supplies. And that was a shortfall globally. And yes, we did have price increases in that. But because we are small, we have very concentrated industries. Because we are small and needing economies of scale, they're big import firms, 2 or 3 at most import firms, sometimes 1 in an economy. And also I have noticed that there are vertical integration, upstream and downstream, vertical integration. And so some of our big conglomerates have vertical integration upstream with presence in Miami, warehouses in Miami, doing their procurement, controlling the shipping, etc. And as a result, I think that actually was the saving grace, because we had all that concentration that was able to keep supplies flowing into our economies. So we haven't really experienced any big shortfall in supplies. So how do our laws respond to this? Well, in my conversations with the commissions, they have not felt the need to make any changes to our laws. We have in our laws, in our competition law, we have prohibition of excessive pricing. We have authorizations. A firm that feels concerned about a collaboration can come to the competition authority and ask for their view on whether this will be anti-competitive or not. Are they in breach of the law? And actually Barbados Fair Trading Commission did have one such approach. And you can apply public interests when you're evaluating authorization. We also have consumer protection agencies under the umbrella of our competition agencies. So it's in one, and our laws include competition, and the competition law includes consumer protection. And so therefore they have been able to emphasize the consumer protection dimension of this.
Thank you very much. Thank you, Taimoon. If we can move on to these questions, we have received several questions. Let me, other than those two questions that I raised, let me also highlight two certain other questions which, for Fred Jenny, there is a question by Douglas Ferrante from Brazil. Are the competition legislation becoming obsolete due to the new digital era reality and the effects and consequences of COVID-19 to the world? Then there is a question to Eleanor from Ambardar. What is the future of competition, convergence and cooperation if there is divergence in the aims of competition? For Teresa, from Dr. Sedu Sako of ECOWAS, Eleanor, that was a question from Ambardar from London. This is a question from Dr. Sedu Sako for Teresa. How did you see the role of regional organizations for guiding their member states? And for Shaista, does the pandemic also increase competition issues due to a risk of consolidation and dominance due to the big players taking over small players who are unable to survive? This question was raised by me in another context earlier. This is a question from Mehta Malhotra of PricewaterhouseCoopers. And for Bill, how far does the response of developed country competition authorities to the COVID-19 pandemic and measures constitute a bending of competition principles? By Rajan Dhanji, formerly with UNCTAD. Let me start with Bill. You have about nearly 4 questions directly, I mean, two to all panelists and 2 or 3 to you. Bill, over to you. Bill, can you hear me?
Okay, yes, okay, so I'll go first. The last question you mentioned, how much bending has been done? It's hard to tell. We have what we can observe most directly are statements by authorities of what they intend to do. How much do we know about what they've actually done in individual matters is very difficult to observe right now. It's hard to see in how many specific instances traditional controls have been relaxed and what the effect of the larger policy statements has been. So a short answer is some agencies have said that they are relaxing restrictions, but typically they're doing it in a context in which they're saying legitimate considerations about improving performance, increasing the availability of supply, increasing benefits to citizens, fits within a traditional framework. So it's, I would say at the moment it's awfully hard to tell. But that's where, when again things settle down a bit and we return to something that resembles our previous experience, that's a moment where we can go back and try to find out exactly how many departures there were. How much did the system bend? Where did the lines move? I think that's something that's worth catching up on later, but I'd suggest right now in individual cases, it's awfully hard to tell. Pradeep, did you want me to address now your question that you posed about the proceedings in the US about tech, or did you want to take that later?
No, I'd be happy if you spoke about that.
Yeah, I think the committee that held the hearings, there was a set of proceedings in front of a committee in one chamber of our legislature. They're writing a report. They probably have written most of it, and I think they're going to recommend three things. One is they're going to tell the enforcement authorities to make more aggressive use of tools they already have. So they're going to exhort agencies to fulfill the apparent intention to bring big tech cases. And my own sense is that they will do that. And by the end of this calendar year, we will have the Department of Justice, the Federal Trade Commission, and our state governments each running at least one big case. And who are two of the most likely targets? Google and Facebook. So regardless of what happens in elections in the US, I would say that by January 1st, 2021, there will be 3 cases running. So they're being exhorted to do that. The second recommendation is going to be change the law to increase the capacity of agencies to challenge behavior. They're going to try to remove some rigidities in the US doctrine by expanding the framework of the existing legislation. And the third thing they're going to recommend is the establishment of a new regulatory mechanism. A regulatory mechanism that gives explicit instruction to a new institution or an existing institution to create codes of conduct that apply to information systems platforms. So 3 recommendations coming. Do more with what you have. We'll change the law to make it more intervention friendly. And here's a new regulatory tool. That's all on the horizon.
Thank you, Bill. I mean, those are good enough indicators for what could happen in India also. All these companies are also under quite a lot of sort of vision, a lot of microscope, I would say. Having said that, may I now turn to Shaista Bano? You heard the earlier question. There's another question to you. What you said that, this is from Freni Patel. She's a journalist who covers competition and regulation issues. So you should answer this question as honestly as you can. If the price caps already existed in the past, which government incentives affected competition or were anti-competitive?
So I will answer the second question first. There have been price caps mostly in the form of support price in agriculture sector, and that are very common in other developing countries as well, such as in the wheat and in the sugar sector particularly, there are price caps. The other price caps or the category of price caps is in the pharmaceutical sector, where some drugs, the prices of some drugs have been capped. In the COVID situation, the various city administration observed that there was exorbitant increase in the prices of hospital facilities. So they put a price cap on various hospitals, the prices of face mask and the prices of hand sanitizer and the prices of other pandemic related drugs as well. So they were the new price caps, and the old one that was there, those were continued, were the price cap on the prices of wheat flour, that is the main essential commodity. There is a law in Pakistan that deals with the prices of essential commodities, and that law basically, some commodities have been already identified as essential commodities, and their price is capped by district administration on monthly basis and sometimes on quarterly basis. So these include the price of milk, the price of meat, pulses, wheat flour, as I already mentioned. So as a competition agencies, we have been advocating with the government to lift these price caps. And we have issued under our law various policy notes to the government to lift these price caps and withdraw from the support price. However, it has not been done yet. So we are currently in the process of reviewing this legislation again after the pandemic situation, because during the pandemic, there was a crisis in the wheat sector, in the sugar sector, in the petroleum sector, the energy sector. So after that, we are again reviewing these things and we are issuing some advice to the government to address and gradually withdraw from these price caps. As regards the second question, that was about the abuse of dominant by the big players acquiring small players in different industries. So far, no such case has been reported with the Competition Commission of Pakistan, but as I already mentioned, that we are closely monitoring the situation, and if we observe any such thing, we will definitely look into it with the perspective and with the mandate that has been entrusted with the Competition Commission of Pakistan.
Thank you very much. Teresa? There were some general questions and some specific questions too. I hope you made a note of them.
Yes, thank you very much. Well, regarding the big tech, I'm afraid I cannot really say anything more after what Bill said. I would just take the opportunity to share that I think for at least 1.5 years, 2 years, all of us, meaning before the pandemic outbreak, we were, I think, observing the changes in the digital economy and the behaviors of digital players. And for instance, within the EU, it was clear that the way the market concentration was evolving and concerns with data protection and consumer protection issues, and also concerns from a sector-specific kind of angle, that we were getting close to some sort of regulation, some sort of regulatory framework. And I know, and as Bill mentioned, that at least in Europe, to my knowledge, there have been discussions on should any future regulation be entrusted to a competition authority, to a sort of electronic communications authority, or should a new authority be created also with some sort of responsibilities as far as data oversight and protection is concerned. I think this discussion is still ongoing. Definitely, I think even for the EU member states, what will happen in the US is extremely relevant, considering how the digital economy is so well established and flourishing in the US. But for now, I don't think we can really, I could not really add anything further. I do think that there is this genuine concern of that this possible new regulation not becoming something that will hamper innovation and the development of new, even if disruptive business models. This is something I can say. Now, getting to the question that I think was asked to me directly, well, UNCTAD, of course, what could we do during the pandemic? Well, first of all, we tried to gather as much information from measures, from initiatives, from new legislation that were being adopted across the world and share it so that this could inspire and support competition authorities, namely young and small from developing countries. I would like to share that throughout this period, of course, UNCTAD, like all the other speakers and colleagues, have been participating and organizing and co-organizing a number of discussions. And I did notice that, for instance, in a number of Latin American discussions, namely with academics, that there was a very key concern of keeping a strict competition law enforcement a little bit regardless of the current context conditions brought by COVID-19. Now, I think this is partly understood when you're talking about young competition authorities, which are probably still in the process of asserting themselves in the market, in society, and so they want to remain as faithful, as close as possible to their mandate. But I think it is important, from my point of view, and from our point of view, that competition authorities showed flexibility. I think that whatever the terms of a mandate, I am quite confident that the mandate of a competition authority allows it to apply the law and interpret it, taking into consideration the special conditions, especially in these exceptional times that we are living, and thereby remaining relevant. I don't ever think, despite being a lawyer, I don't ever think that the first initiative should be, oh, we should change the law, or we need new legislation. Even though, of course, I understand as a former public civil servant that one tends to use the instruments at stake also to convey messages, so to create, to give guidance, to create more predictability, to try to increase transparency. But I do not think that it is, as Bill said, I would absolutely agree, it is probably too early to start really going into the amendment of legislation while we are still very much in the middle. We don't know how long this will take. For some months we have been discussing the post-COVID context, but we may be still far from this post-COVID context. So getting back to the ECOWAS question, we will be very happy to share the best practices and thereby to support any competition authorities. I would underline that we do believe that regional competition authorities have a very important role, especially when we are talking about developing countries as member states, because even though several member states of developing countries have adopted, enacted competition laws, this may be still in the early stages of enforcement. They may still have young and little resourced authorities. So we do believe that regional competition bodies can play a major role, and UNCTAD is here with other international organizations and partners to support them. Thanks.
Thank you very much. May I turn to Taimoon? Taimoon, you have a question from one of your colleagues in the University of West Indies. Try to see. Just give me a second. One question is that you mentioned that the pandemic offers competition agencies to increase advocacy and suggest changes to competition law based on what worked or rather did not work. What changes do you feel are necessary based on what we have seen thus far? And I'll go to the second question also, so that you can take up both of them together. Yeah, this is from Teresa Prescott, the University of West Indies. What effects would current day relaxation of competition laws have for future enforcement, particularly in smaller, younger jurisdictions? Over to you, Tim.
Thank you, Pradeep. So the first question actually allows me to make the last point I intended to make in terms of advocacy. And that is at the regional level, the CARICOM Competition Commission was able to get a collaboration. They initiated a collaboration with competition agencies, consumer agencies, and trade officials, and set up a steering committee and an action plan to monitor markets and to engage in advocacy. And the advocacy really centers both on alerting businesses to what we consider as anti-competitive, and also alerting consumers on being vigilant for price increases or excessive price gouging. And I actually asked some questions of my students across the region, particularly the OECS, and found that actually, yes, there are radio ads, newspaper ads, television, etc., from government agencies alerting consumers to be vigilant, to bring in receipts if they were too excessive, if they found considered too excessive, etc. In terms of what needs to be changed in advocacy, at this time we are actually doing very well with advocacy, and we are actually the CCC is doing a very good job in bringing together the entire region. So once again, there's a regional collaborative effort that worked. So I don't at this moment see any advocacy changes, except that an intensification of advocacy to government ministries that where they are necessary. And the second question, relaxation of competition laws, was that it? Can you repeat that? Yeah. No, in talking to the legal experts in the competition commissions, they felt that it is better to have the existing laws, to have the flexibility to apply the laws, and our commissions have traditional discretion. They can choose their cases. They have the ability to apply public interests, and they prefer to actually stay with what is and allow certainty to market players and give them that flexibility reside within the commission, so that at this point there is no debate about changing provisions in our laws or relaxing provisions, but simply applying public interests to examine cases.
Thank you. Eleanor, other than the questions which I've already posed, but I would like to underline one and two questions. First is in terms of what is happening is the pandemic, the economic downturn has led to several small units becoming sick, and they then become an easy prey to the larger units who can afford to absorb them. Do you think there is a need for some kind of state support to such kind of small units? For several good reasons, I would say. Of course, I mean, if you look at the Chicago style of thinking, perhaps it would make sense. But if you look at the developing country issue, this question of jobs, and so many other reasons that this could be a question. Secondly, the question which has been raised to you particularly, which is what I read out to you, and if I can yeah, what is the future of competition, convergence, and cooperation if there is divergence in the aims of competition? This is by Amber Dar from London.
Okay, thank you. And this gives me a chance to circle back to your initial questions also. I would like to say, what is the future of convergence and informed divergence? Because I think that that's the direction that we have to be thinking of. We should not be thinking of one model, one way, and we should be thinking about understanding what other countries are doing, possibly with a view to taking it on board for our own law, but possibly just with a view to understanding and clarity. So I think that the future of convergence with informed divergence is good and better than it ever was, even though there are big areas of divergence. Oh, so I'm taking your second question first. I think that as the competition authorities and the international authorities, the international organizations, OECD, UNCTAD, ICN, should recognize the convergence against parochialism and parochial nationalism and play with that, because that is so big. And it turns out that when the pandemic came upon us, 69 countries immediately put in export controls on things like masks and ventilators, when actually there was hoarding of some in some countries. The need for the global vision is so important not to be corrupted by parochial nationalism. So after you get past that, which I think should be recognized, then there's a lot of convergence. There always is divergence. I think there are about 5 particular issues in which countries are beginning to accept different ways of doing things. So one that you've just mentioned, different in view of different goals. What are the different goals? One goal would be narrow output limitation allocative efficiency, which some people have, but I think there's an increased appreciation that even to get efficient working of markets in other places in the world, you need a broader goal to look at market process. And I think that that takes care of a lot of the divergence on goals. After you get past that one issue, there are other divergences, some that you mentioned before, Pradeep, such as public interest and whether goals such as sustainability could and should be accounted for, even with competition law. And I put that in the bundle of informed divergence, rather than saying there's one right way to do it, there's only this way. I think people are recognizing this environment is one of the great issues of the world, and many jurisdictions are recognizing that must be brought into the competition law. I think sustainability, other public interests such as how to deal with national security, those are actually, those are 2 of the big issues that countries deal with it differently. On dealing with national security, there is the big problem that companies that want to get their mergers through always play the national security card when it really doesn't exist. And there's a narrative that is very acceptable to a lot of agencies today, to accept this narrative, beware of China and let our big merger go through. And that doesn't fall into anything but trying to find out the truth of what is happening, and for agencies to be more aggressive and skeptical. So the future of convergence with informed divergence is good, and I think there's room for OECD and UNCTAD, Fred and Teresa, to work in that area of what are these issues in play and how to take on board what different countries are doing about them. Oh, I'm sorry, should we give, your first question, should we give aid to support, for example, SMEs because they're really losing out in this COVID era? My response would be to say, again, that's very much a question of what authorities choose to do. I think the EU is a very good example of thinking carefully about when the aid is necessary. I would prefer a track of talking about what is anti-competitive and how to define exclusionary practices, because I think a huge amount of the problem, this goes to high tech too, huge amount of the problem is big firms that control most of a segment of competition are doing real exclusionary practices that hurt small and middle-sized enterprises. And sometimes you cannot prove this is against consumer interests. So we circle back to the first question, but there is an imperative to make the market process work to control and prohibit the exclusionary practices of dominant firms. So I would work at that end, what is an anti-competitive exclusionary practice, more than I would work on the end of giving out aid.
Thank you very much, Fred. Fred, are you there? Frederic, Jenny? keeps on coming and going. And he probably has some problem with his equipment, I think. Fred?
Fred has dropped out. Some problem with his internet connection.
I thought as much. Bill, maybe I could pose some questions to you, which were raised to Fred also. Collaboration, especially in healthcare and pharma sectors, was essential in the earlier months of the pandemic, but perhaps it is no longer needed now, as these sectors have understood the difference between antitrust breach and exemption. Should the exemption not have an outer limit? By the way, but I must respond to a point which was made by Eleanor in terms of protectionism. India had banned exports of medicines and PPE kits, etc. But suddenly it found that it has actually a higher capacity to produce, and it opened it up. I'm talking about India, US example, for example, and until Donald Trump called up Modi to say that, look, we need these medicines, hydrochloroquine, the long twisting name. I don't know whether it is effective or not in terms of COVID. But that said, Bill?
A concern that has a lot of historical antecedents is that if you override existing limitations, the override becomes permanent, that it has lasting effects, that firms continue for a longer period of time to act as though the previous rules didn't exist and been relaxed. So how do you avoid the durability of limitations or dispensations that were designed to deal with an immediate exigent crisis? I go back to Eleanor's original comment in her first presentation that I think there is a great deal of room in competition law to contemplate collaboration that enables firms to accomplish socially beneficial outcomes that were not attainable if single firms acted individually. Even in good times, two firms come forward to the agencies and say, here is a breakthrough that we think is attainable. Neither of us has the resources to do that, but we have complementary skills. May we perform the equivalent of a joint venture-like arrangement for a period of time to achieve this? Now, an agency will test them to make sure that those assumptions are correct, but I can't imagine a competition authority saying no. That is, if we accept the premise that there is a desirable, socially beneficial breakthrough that you'll accomplish, that you couldn't do it alone, that with a collaborative effort you'll achieve that, I think that survives antitrust scrutiny even without a crisis in the background. So I start with Eleanor's point about how existing tools and existing frameworks welcome certain types of inter-firm collaboration that achieve outcomes that were not otherwise attainable through individual action. And that's always going to be a constant. So those kinds of cooperation go ahead. I think what we're talking about are additional forms of integration that exceed what we would accomplish under that pre-existing framework. And for those additional types of cooperation, where, for example, firms decide who will produce what, how they will distribute their output, I think it's important to make clear that those are temporary and not lasting measures. And to make clear that when the crisis has abated, although I accept the caution that Teresa mentioned, who knows when that's going to be? Is that the end of this year, 2021, someday? Who knows? But when it has abated, that you cannot continue to completely integrate your operations in this way when the pressing need has disappeared, and that remains an important objective for competition agencies. And there will be a byproduct of the collaboration, which is that firms won't forget how they collaborated. What they do in the course of collaborating in these ways is to learn a lot about the other firm. And there will be a residue of this, which competition authorities will have to be alert to over time. So in short, I think there's a lot that companies can do now where they have the kind of justification that Eleanor was mentioning before. Competition law embraces these things. The real concern are additional forms of collaboration that involve broader contractual integration that will have to come to an end when the crisis abates. And there will be a residue of understanding and perhaps tacit coordination that takes place because the experience of cooperation teaches each firm a lot about how its counterparts behave.
Thank you very much, Bill. What has been happening is, I think most of you would be aware that we've been behind celebrating the World Competition Day on 5th of December. And every year we've been adopting a theme to take it forward. Now, there are two big issues which concern consumers nowadays, and this is what we did over the last two World Competition Days, is to deal with the digital economy. And this World Competition Day, we're going to look at healthcare, which is becoming a very, very, very major area of strength, and particularly in the background of COVID-19 and the kind of things which have been happening. And therefore, I request your attention to this particular issue, which we put out soon. And with that, may I now request Udai to please propose a vote of thanks and to summarize this very rich event. And I would say I would like to thank the audience, and some of them have left, but we had a fantastic audience from across the world. I counted on a rough scale about 60 countries in this webinar. Over to you. Better than most of us can do without any cost. Udai.
Thank you, Mr. Mehta. I think extremely rich discussion, and I think the last part of my job is to summarize, which is extremely challenging given the kind of speakers and the richness in their contributions which we had. Nevertheless, I'll try my best to comprise and these sessions into 4 or 5 key points which emerge from the discussion. I think the first and the most important point which we started off the seminar was focusing on that these are unprecedented times, and the measures which we are witnessing, whether they're hindering competition or not, are unprecedented. But the key thing is to understand and to always keep at the back of the mind is who are getting the benefits, is the consumers or the businesses. And as a consumer group, I think at the end of the day, the interest of consumers is the key. So that was, I think, one of the crucial points to begin the webinar. Going further, there were certain discussions around how competition agencies reacted to these situations. And I think there were 4 or 5 points which emerged on the basis of how competition agencies have reacted. One was the freedom to which they can prioritize cases so as to ensure that they're not overburdened with cases and they could prioritize and react to some important and essential cases. Second was the issues around public interest goals, which do find place in certain competition agencies and competition laws in developing countries. Third point was in around the flexibility in efficiencies. And with the specific point which was raised was under which criteria can efficiencies be accepted. And last but not the least, the extent to which competition law can accommodate or have a very strict interpretation when it comes to cooperation. Talking about cooperation, just to move on, I think one important point which was raised was cooperation not in just terms of the general and narrow sense, but it should be looked at it from a broader sense. And also for the fact that the exchange of cooperation should also be focused more on looking at how practice and know-how can be exchanged and not just theories. And in that case, undertaking detailed case studies from agencies on how they have done those case studies, what have they learned, that could be shared, and that would really mean the true sense of cooperation. An interesting point which was raised about competition agencies was the need to analyze data in real time and also have a process to communicate what the decision making is in the larger public, use media, use civil society to communicate their decision making, so as to also ensure that there's transparency and to also get a buy-in from the consumers and producers on decisions being taken by competition agencies. At the same time, an interesting point which was flagged was that one also needs to be skeptical about the need to collaborate. One should not just give away exemptions or privileges to large group of companies or businesses. So there's a need and a necessity to ensure that the termination of the collaboration and how efficiently it meets the needs to be analyzed and looked into it. An important suggestion which emerged for all the competition agencies globally, that is, it's extremely important to have truth in their analysis. In certain jurisdictions, it has been visible that they have been bending the laws. Thus, it is extremely important for agencies to call a spade a spade. Last but not the least, for the smaller economies, given that they are small in their own geographies, and the fact that they have been island countries was a positive in one way for their situation to deal with the COVID. Given that once they closed their borders, nobody could come in, and they had very few hospitalized cases and deaths. So the management of the virus when it comes to smaller economies has been slightly more effective given the geography. Given another important point which was also emphasized was the changes which are happening at a multilateral trading system. Given that many countries are going and undertaking protectionist measures, which itself is an opportunity for us to also assert the need for competition policy. And it is an opportunity for competition agencies to do more advocacy and make possible cases for benefits of competition. And last but not the least, I think the last point which emerged from the panel discussion was there's the increase of market dominance for large digital players, which requires regulation and competition to be analyzed. And it is extremely important that startups are not just brought by bigger companies by taking into account the consumer's interest. And the last important point, which also was spoken about and to be highlighted, is the efforts being taken by Competition Commission of Pakistan, which we have also noted in the past, is the issuing of policy notes and opinion to government agencies. And that is a lesson for other agencies to also be more proactively engaging with government and other departments. With that, I just want to re-emphasize that at the end of the day, what's really important is to also analyze and understand who are getting the benefits. And I repeat the point, whether it's the consumers or the businesses. With this, on behalf of CUTS, I would like to thank all the esteemed speakers, the senior management of CUTS, the team at CUTS, and also all the participants for taking out their time and for being part of the webinar. Apologies for not taking all the questions. We had plethora of questions which were targeted to the participants, to the speakers, but because owing to the paucity of time, we could not take all the questions. And towards the end, I could only say, as the co-author of the paper, along with my colleague Sakhi, the webinar has given us immense food for thought. And I'm sure it's an opportunity for us to revisit the paper in the near future. With this, we officially close the webinar. Thank you once again to all of you. Thank you to all the speakers and the participants. I can only say good night, good morning, and good afternoon to the participants. Thank you very much.
Well, on the western side, have a great day. And on the eastern side, have a good evening.
Thank you to all of you, and stay safe.